Welcome to our continuation lesson on express private trusts. In the last tutorial, I discussed the creation and the formalities for creation of express private trusts. So I talked about how express private trust is created and the formalities thereof. And if you study carefully, listen and watch carefully, you understand that how the formalities depend on whether the trust is one which is to take effect in survival during the lifetime of the settlor, or is one which is to take effect after his lifetime, and that one is the one created, is the trust that is created by will. So if it is the one that is to take effect during his lifetime, in that case it will be either by declaration or it is one that must be in writing and signed, where it involves trust of reality. But if it is by will, then it must comply with the formalities for a valid will. That's just the formalities for creating a trust. In this lesson, we want to look at the 3 requirements for the validity of trust. The 3 requirements for the validity of trust, or you can also refer to it as the essentials. The essentials of trust. So there are 3 essentials, or you can also call it essential requirements. There are 3 essential requirements for the validity of trusts. Recall in the maiden, if you have seen the first video, I mentioned the general. There is general requirement for validity of trust. 1, it must be a trust of specific property. It must also reflect the settlor's intention. Then it must also be for lawful purpose. Those are the general requirements. Then beside that, we have what is referred to as the 3 requirements for the validity of trust, also known as the 3 certainties. So the 3 certainties for the validity of trusts. There's what is referred to as the 3 certainties. And what are the 3 certainties? The 3 certainties for the validity of trusts was they were laid down in the case of Knight versus Knight by Lord Langdale. So Lord Langdale laid down or stipulated 3 certainties for the validity of trust. The 3 conditions that a trust must meet for it to be valid. And what are the conditions? We have a certainty of words or intention, certainty of subject matter, and certainty of objects. Those are the 3 certainties for the validity of trusts. Certainty of subject matter, first, certainty of words or intention, certainty of subject matter, and certainty of objects. Now let's briefly look at what these 3 certainties requires of the settlor. You know, express private trust is the one that arises by the deliberate or intentional act of the settlor. So the settlor in creating this trust must ensure that all these 3 things, they are certain. He must make all these 3 things certain. Let's look at them. The first one is certainty of words or intention. What does that require? First, generally or by common sense, you should know that if somebody has intention to do something, the intention dies with the person until he express that intention. And if he just keep it in his mind, then so be it. It will remain with him and die with him. So if a settlor wish to create a trust and he has it in mind, he must express it by words, and this could be by word of mouth, orally, oral declaration, or in writing. But by this requirement, it's not sufficient that he just express it by words. The word he used must be certain enough to show that he actually intend to create that trust. That is, his word must be imperative. He must use imperative words in order to show that he intends to create that trust. Now the important question now is, does creating a trust requires the use of technical words or technical language? No, it does not. Does it requires the donor or settlor to use the word trust in the instrument? No, it does not. What is actually required is that the word used, when construed, should actually show his intention to create a trust. When the whole instrument is read, it should be deciphered. It should be seen that the settlor actually intended to create a trust. It must be shown that he actually intends to impose an obligation on the trustee. So his word must be clear, unambiguous, and point to the irresistible conclusion that he actually intended to create a trust. Therefore, take note that the use of precatory words will not be sufficient and will not create a valid trust. The use of precatory word is not will not create a valid trust. And what are precatory example of such precatory word is in confidence, hoping that, in the hope that. Precatory words are words that express wish or moral obligation, but they did not such word did not create any binding legal obligation. So there are some words, they are referred to as precatory words, in the sense that those words, you are not, when you use them, you are not actually creating any legal binding obligation. You are just expressing your wishes or desire. So such are precatory, and such words will not be valid to create a trust. And we have illustrative cases that illustrate where a trust fell for uncertainty of words and intention. One of the locus classicus case is the case of Re Adams and Kensington Vestry. Re Adams and Kensington Vestry, or Re Adams versus Kensington Vestry. And what happened in that case? In Re Adams versus Kensington Vestry, in that case, the testator gave all his real and personal estate property to his wife in the following words. Look at the word he used. In full confidence that she will do what is right as to the disposal thereof between my children. So the operative word here is in full confidence. So the testator give it to the wife in full confidence that she will do what is right between my children as to the disposal or as to the sharing of the property. It was held that no trust was created in favor of the children, and the wife took it beneficially. So the word used here now is precatory words, in full confidence. The word is not creating any binding obligation. Another example case is the case of Mosori versus Renault. In Mosori versus Renault, the testator also gave property to his wife, and this is the word he used, and feeling confident that she will act justly to our children when no longer required by her. So just like in the first case, it was held that there was no trust created in favor of the children, and the gift was given, it was treated as a gift. The property was treated as a gift to the wife, so the wife took it beneficially in this Missouri, and also in the case of Ray Adams versus Kensington Vestry. So that's what the first requirement is all about. The second one is the certainty of subject matter. The certainty of subject matter. What is the subject matter of a trust? The subject matter of a trust is the trust property. Just like the object is the beneficiary, we have an object and subject of trust. So the subject of a trust is the property. So another requirement is that the property that is to be the subject matter of the trust must also be certain, because one of the elements of a trust is the trust property. So there must be a property, and it is reasonable. This requirement is reasonable in the sense that the property should also be certain. We must know which property is to be the subject matter of this trust, and this requirement has two heading or two aspects. One is certainty as to property, and then certainty as to beneficial interests. So the major heading is certainty of subject matter, and under certainty of subject matter, we have two aids or two aspects of it in relation to certainty of subject matter. One is certainty as to property, and certainty as to beneficial interests. Now, what does each of these entails? Certainty as to property requires that the property that is actually to be the subject matter of the trusts must be made certain. So, which property does the state law want the trustee to hold on trusts for the beneficiary? It must be made certain. Otherwise, a trust cannot exist without any property, because trust has to do with holding property for another person. So if we can't identify the property we are talking about, then there will be no trust. So there is the property first must exist in the first place. The property must exist, and then it must be capable of being identified. It must be identifiable at the time when the trust is created, or even if it is not so certain, let it be capable of being identified when the trust is created. So the state law or the trust instruments must make it clear which property is to be bound by the trust, otherwise the trust will fail. So the state law must state it clearly which property is bound, is the subject matter of these trusts. That's what the requirement entails. And we have illustrative case. We have the case of Ray Jones. Ray Jones, in that case, the testator, after making absolute gifts to his wife, directed that after our wife death, such parts of my estate as she shall not have sold or disposed should be held on trust for some persons. That's what the testator stated, that he gave the estate to his wife, and then now directed that okay, anyone that was not sold or disposed by her should now be held on trust. The trust fell because in that case we don't know which part of it is not known which part of the property at the time of creating the trust, or when the court is interpreting this trust, it will not be known which property that the wife will not dispose, or the part of the property that the wife will not sell. So the trust fell for certainty as to property. Also, we have the case of Palmer versus Simons. Palmer versus Simons. In that case, the word used by the settlor was the bulk of my residuary estates. So the operative word in that case was the bulk of my residuary estates. That's what the settlor directed to be held on trust for certain person is bulk of residuary estate. The trust fell because the phrase was not certain enough. It could not be determined which part was a residuary estate. Then certainty as to beneficial interest. I told you that certainty as to subject matter as to limb. So one is certainty as to the property and certainty as to the beneficial interest. So after the property is identified, the next requirement is the interest of the beneficiaries. The extent of the interest of the beneficiaries must also be identified. The value, the exact value of each of the beneficiaries' interest must be certain and must be identified. Or if it is a particular, in terms of property, the exact property which is to be given to a particular beneficiary must be certain, must be made certain. This is what this requirement requires. And we have one illustrative case there, which is the case of boys versus boys. Boys versus boys. In that case, the settlor gave 2 houses on trust to trustees with the discretion to convey one of the houses to Maria, whichever she may think proper to choose or select, and the others conveyed to Charlotte. Maria predeceased the testator and did not have the opportunity of making a choice before Charlotte. It was held that the trust failed as the property to go to Charlotte cannot be ascertained. So you can see in this case now, the settlor gave 2 houses to trustees to hold on trust for Maria and Charlotte. And the direction or the word used by the settlor was that first, Maria should choose any of the houses, whichever she deems fit or she thinks proper to choose or select. Then after selecting, the order of the house should go to Charlotte. However, Maria died before Charlotte. So since Maria has not selected, it is not therefore certain which one, it cannot therefore be determined which one she would have selected and which one would now go to Charlotte. That was how the trust failed for certainty as to the interest of Maria in this case. So certainty as to the interest. However, in contrary to that above, in the case of Rigole, the trust which stated one of my flats and a reasonable income was held to be certain enough to constitute a valid trusts. Then finally, the last requirement is certainty of objects. Certainty of objects. As I've mentioned that the subject of a trust is the property, while the subject of a sentence is the person or thing that is being spoken about, that the sentence is about, apart from you saying the doer of a sentence. So in a trust, the most important is actually the property. But if the property is not there, there will be no trust. Then another thing is the object. The object is the beneficiary or the purpose for which the trust was created. So the last requirement is the certainty of objects. Certainty of objects. So certainty of objects relate to the beneficiaries who are entitled to the trust property. So the beneficiaries who are entitled to the trust property must be clearly identified. So we must know who are those to benefit. I think Lord Langdale did well. These requirements, they are reasonable. If you create a trust for the benefit of persons, you should be able to state clearly who are those persons, who are those beneficiaries, what is the object of the trust. So it must be clearly, otherwise the trust will fail. The trust will fail. And the illustrative case under this aid is Brown versus Gold. Brown versus Gold. In that case, the word used by the donor was my old friends. My old friends. My old friends. So the trust, the donor wants certain property to be held on trust for his old friends. For his old friends. So it was held that the phrase my old friends lacked precise definition, and the trust fell for certainty of objects. So those that the law or donor want to be the beneficiary describe them as my old friends in Brown versus Gold, and the trust failed for certainty of object because the object were not certain. Now this my old friend, in my view, it will now require the court to answer two questions. And what are the two questions? This old friend, is it referring to age or time? Is it referring to age or time? So for instance, is it referring to his friends that are old, or is it referring to his long-time friends? Those are the questions begging for answer with this word used. So the object, they are not certain, even if it is required to his in terms of age, which range, which range. If the settler was referring to if the old is referring to age, which age range? Even if it's referring to long friends, long time friend, how long? So you can see how uncertain the object of the trust is. You can see how uncertain. So there is basically what the trust certainty entails. Now, finally, what are the effects of uncertainty? What are the implications of uncertainty? That is, whenever there is uncertainty, what will be the result? What will be the consequence? What will happen to that particular trust after it has failed? What will happen to the trust property? Now, whenever there is failure of, whenever there is uncertainty of words or intention, the trust will fail, it will be invalid and ineffectual, and what will happen is that the trustee, the purported trustee, will take it beneficially. It will be treated as a gift to the trustee. In the same vein, whenever there is uncertainty of objects, whenever the whole transaction will be ineffectual, the trust will, no trust will be created, it will be invalid, and the donee will take it the first place I said the trustee will take it beneficially. The proper word should be the donee, because since there is no trust there, it cannot be properly be described as a trustee. So it's the donee, because the property is treated as a gift to him. Since the property is transferred, conveyed to him, so the court will treat it as a gift to him, and then so we will not take it beneficially. In the same vein, where there is uncertainty of objects, the whole transaction is ineffectual, no trust is created, the trust is invalid, and then the donee too will also take it beneficially. Then whenever there is uncertainty of objects, whenever there is uncertainty of objects, that is the beneficiaries are not certain. In that case, there will be a resulting trust to the estate of the settlor, donor or testator. So as when we'll be looking at resulting or implied trust, you will also see that one of the situations or circumstances where there will be resulting trust is when express trust fail. But just take note at this point that whenever there's a failure of an express trust, then there will be a resulting trust to the estates of so the trustee will hold it on trust to the estate of the settlor or donor. Those are the effects of uncertainty. But before I conclude, I would love to state this point that initially the court of equity, they are always ready to find that there is a trust even when there is a uncertainty in relation to uncertainty of words. For instance, if there is uncertainty of word or intention, because equity look at the intent, the court are always ready to infer that. And that has been the case till in a particular case where it was held otherwise. In the case of Am versus Ems. Am versus Ems. Let's hear the statement of his lordship there. In the case of Am versus Ems. Okay, it's not Am, it's Lamb. Lamb versus Ems. So in that Lamb versus Ems, James LJ make this observation. His observation state the reason why the court should not always the court of equity should not always say that or hold that there is a trust when the words are uncertain. This is reason. He observed as follow. After hearing many of the older cases, before, even where the words are uncertain, the court of equity still hold that there is trust. And in this case, it's saying that after hearing the older cases, I could not help the feeling that the officious kindness of the court of chancery in interposing trust, where in many cases the father of the family never meant to create trust, must have been a very cruel kindness indeed. So his lordship said that for a court to interpret or to hold that there is trust where the word is not certain to show, to indicate that the person intend to create a trust, is a cruel kindness. It's a cruel kindness. And I agree with him to some extent, because a trust is a very onerous task, and generally the trustee, they are not entitled to any compensation. So you don't need to put such onerous tax on a person. The court don't need to impose such tax on a person when they do not actually wish to impose same. That is when the court started being strict with the requirements of certainty of words or intention. And it should be noted that one of the problem of this issue of uncertainties is because it's due to the draftman pattern in those days. And in those days, it was not lawyers they were drafting, but it is submitted that in these days where we now have lawyers who solicitors who drafts, then the problem will be rare to occur if the work is done by solicitors. So we'll end here. This is the end of the discussion on express private trust. In our next video, we'll go to another classification, either constructive trust or public trusts. So don't fail to also continue to see, so that you understand the full crux of this particular topic. Thank you. If this is your first time of seeing my video, please don't forget to like, share. The first thing is even subscribe and press the notification button so that you can always receive my video. Then the next thing, question. Don't forget to react in the comment section. If you have any question, or for instance cases that I always cited, I don't put the citation. So if you need the citation of cases, don't forget to comment and request that in the comment section, because I will always see the comments. Thank you, and see you next time in the next video.